can start.
Yes.
Good morning, everyone. We are welcoming you all to this one-day online program on cyber laws, handling and appreciation of digital evidence. This particular area is the most challenging area. Cyber laws, cyber crimes, digital evidence investigation, the different components of this. Are the components something of the future for that matter? Technological developments have to keep pace with the kind of crimes which are being committed in the present context. Cyber crimes, particularly in the domain of financial crimes, are affecting the society at large. And therefore, this is an area which needs to be looked into deeply, effectively, so that the investigation agencies are able to perform their duties, functions effectively, and the adjudication at the level of the judges becomes more effective, meaningful, wholesome. That's the basic purpose, to sensitize our judicial officers dealing with these specific matters as such. The Cyber Laws, Information Technology Act, and various other aspects are going to be covered during the course of the day. This webinar has been divided into 4 different sessions. The first session we are going to devote to the contours of cyber crimes. And we have with us this morning for this particular session, Mr. Nisheeth Dixit. Mr. Dixit is a mix. Academically so sound, professionally so competent, and combines rich experience, particularly in this domain. He is MSc in Cyber Forensic Information Security, Masters of Law in Cyber Law and Cyber Crimes, MBA, LLB, BSc Honours. Not only this, the different certificate courses in this domain he has done from the best of institutions. And I would like to share the different courses that he has done. Criminal Justice and Data Analysis, IIT Kanpur. Ethical Hacking and Cyber Security, IIT Roorkee. Legal Regulations of ICTs, IIT Kharagpur. Cyber Law, Cyber Forensic, NLIU Bangalore. Cyber Laws, Indian Law Institute. Coming to the professional experience of Mr. Dixit, an advocate for more than 20 years, particularly focusing himself into this domain which he is going to share with you this morning. He is the guest faculty with the best of institutions National Police Academy, Hyderabad, Central Bureau of Investigation Academy, Ghaziabad, Central Detective Training Institute, Jaipur, Ghaziabad and Chandigarh also. Rajasthan State Judicial Academy, Jammu and Kashmir Judicial Academy, Uttarakhand State Judicial Academy, and today this morning he is also with the Chandigarh Judicial Academy. I am so very happy to welcome you. And before I hand over, I would make a request that you can file your questions in the chat box, and the session later on would be moderated by our faculty, Madam Harshali Chaudhary. May I request Mr. Dixit to take over the session. We are very happy to have you with us this morning. Mr. Dixit. Over to Mr. Dixit.
Sir, switch on your mic.
Sir, you are not audible, sir. So kindly switch on your mic.
Yeah.
Yes, sir. Now you are fine, sir.
Yes. Thank you, Balram, sir. Thank you, Chandigarh Judicial Academy. Thank you, ma'am. And thank you all officers who have joined today's session. I hope I am clearly audible and my PPT is visible.
Yes, sir.
Okay. So the most important part is the understanding of cyber crime. So practically, we will discuss three categories in cyber domain, what type of cases we are handling before honorable courts. So theoretically, if we go through by the cybercrime definition, which is worldwide famous, is cybercrime is a term used to broadly describe criminal activity in which computer networks are a tool, target, or a place of criminal activity, and include everything from electronic cracking to denial of service attacks. So first is the target. So crimes where computer is the target of crime. Suppose my system has been hacked, my Facebook account has been hacked, my Telegram has been hacked, my mobile device or my server has been hacked. It means it's a targeted attack. So we have three sections in IT Act. So we can cover in three parts, you can say. If my system, this laptop, which is known as like communication device through which I am able to communicate with you all. So this communication device has been hacked by some cyber criminal. So the section is 66 read with 43 small a IT Act, because my system has been compromised, my system has been targeted, it has been hacked. So 6643 small a is bailable offense, cognizable offense, and its punishment is up to 3 years. But suppose this system has been declared by central government or state government as a protected system. Suppose my system has been declared by central government as a protected system under section 70 in Gazette notification. Now the punishment is up to 10 years, and it is non-bailable offense and cognizable offense. So section 70 also covers the hacking part when the system is declared as a protected system. So simple hacking is 6643 small a, 3 years, and if system has been declared as a protected system, then it covers under section 70 for 10 years. And if it has been compromised and it has adversely affect the protected system to cause death, to disrupt essential services, now it becomes section 66F, cyber terrorism, and the punishment is up to life imprisonment. So we have so many cases where system has been compromised. System, suppose I have sent a judgment to you all and you have all have downloaded and it has bypassed your cyber security. Now I can use your system as malware infected devices, or you can say zombies, or you can say botnets like sleeping cells. So I can use your system as a zombies. I can attack on any other company's server by way of using your system. So means your system has been compromised. Now I am using your system as a tool of crime. So this is a dangerous part. One very important case is that drive-by download. So you have downloaded that judgment and then after your system got compromised. Now I can remotely control your system. So first is the target attack. Second is I'm using your system as a tool. Suppose somebody has used your Wi-Fi. Somebody has used your hack your hotspot mobile and is using your internet computer network. He is using your computer network. That is also a tool of crime. And thirdly, that incidental to the commission of crime, that like means data alteration. Somebody intruded your system. He has altered your database. He has altered your information, diminish its value. So we will discuss section 43I, F, E, which will cover all the things like data alteration or data diddling. So theoretically, we have three cases and practically we have also three cases. First is the target, then tool, and the place of criminal activity. The most important thing is, what do you mean by cyber crime? Cyber crime, practically, yes, if somebody is using information communication technology, computer system, computer network. I am the originator. I have sent content to Harshri ma'am. She is the originator addressee. I have used my communication device. She is using her communication device. I am using my ISP, my intermediary. WhatsApp is my intermediary. I am using my internet, or suppose I am using somebody's internet, like by way of broadband, by way of Wi-Fi. So whether I was authorized to access that computer network, whether I have used another person's communication device. So that depends upon the case-to-case basis. So we have three categories in cyberspace cyber crimes. First is, suppose I have used my communication device. So I'm using my communication device, and by way of using my communication device, I'm using my office broadband. So I'm using my computer network. If I'm sending a content, or I'm calling means any of you and threatening you, any person, means I am threatening Harshli ma'am. So it is a cyber crime because I have used my communication device, my company communication network, and I have threatened ma'am. So it is a cyber crime, but it is only punishable under IPC. There is no IT Act involvement. So cybercrime, doesn't it mean it always attract IT Act? So we have three categories. First is the cybercrime, but it is punishable under IPC or local law. Suppose I have commented on Facebook. I am using my communication device, my communication network, and I have uploaded one content and I have commented that this officer is a corrupted officer. Again, it is a cybercrime, but there is no IT Act element. It only covers under IPC and it is punishable under section 499 and 500 defamation part. So it's a non-cognizable offense. So first category we have, it is cybercrime, but it is purely punishable under conventional law, IPC or local laws. Who can investigate these type of cases? Because it is a cybercrime, but there is no IT Act element. So sub-inspector or any competent officer can investigate these type of cybercrime cases because there is no IT Act involvement. So first category, cybercrime, punishable under conventional law, IPC or other local law. Second category, where a person has downloaded a photograph of a girl, and then after downloading of that girl's photograph, he created a forged electronic record to disrepute that girl. And then after converted that content in an obscene content. So first he downloaded, he used her identity, that photograph, unique identity he has used. Then after he created a forged electronic record, then converted in an obscene content, uploaded on Facebook, mentioned her mobile number and used some ill words against that lady. So here he has done IT Act and IPC, both acts. You can say. So first he has used her unique identity, that is 66C IT Act, punishment for identity theft, because he has used her unique identity. Then after he created a forged electronic record to disrepute that girl, that is 469 IPC. And third, he created a forged electronic record and converted it into obscene content uploaded on Facebook, that is 67 IT Act. He commented like he used ill words. It can be a 354A IPC, it can be 509 IPC, or people are calling that lady, sending messages, WhatsApp again and again, repeatedly, and she is not replying that content. You can say that is 354D cyber stalking. So in second category, we have two things like IPC and IT Act. So we can invoke both IPC and IT Act against that cyber criminal who can investigate second category crimes. Yes, so section 78 of IT Act says, notwithstanding contained in CRPC, not below the rank of inspector shall investigate IT Act offences, because in the second category, IT Act is here. So here inspector has to investigate these type of cases. So second category, IPC and IT Act. Third category, very important as a defense lawyer, we use sometimes the third category, you can say. So third category, we have very important section in IT Act, that is section 81, overriding effect. So IT Act is a special act. If it is inconsistent with other act, it is having the overriding effect over general acts. But there is a proviso. Proviso says that there is no overriding effect over where patent and copyright acts are involved. So we can say exception is Patent and Copyright Act. So we can discuss two very important case studies like Baji.com case in 2004. In 2004, there was no POCSO Act, there was no child pornography section in IT Act because it came after 2008 amendment. So what happened in Baji.com case? There was a case where there is a renowned school in Delhi, and a boy and girl were involved in a sexually explicit content. It was captured and it was uploaded by an engineer on Baji.com website. It was downloaded by 7-8 people by way of using credit card, debit card. The beneficiary was the company. Immediately, the company's managing director was arrested. So there was a chaos. There was chaos regarding what is the liability of intermediary, what is the liability of that website, because what about the safe harbor law? What about the European Union directives? What is the liability of a directly intermediary? What about a takedown notice we have now in section 79? So that's a very important case study, Baji.com. So immediately the managing director was arrested. But the most important thing is that section 85 IT Act, offense by companies. The proceeding against managing director was quashed by Honorable Court because company was not made as an accused. We have section 85 offense by companies in IT Act, like in PMLA we have 70. In NDPS, we have section 38. So this is the very important part in IT Act also. If there is any involvement of a company, first we have to make company as an accused. So in this case, company was not made as an accused, and the managing director was free at that time. In this case, there was a co-accused. There was a co-accused, that is Sharat Babu Digumarti, a very important landmark judgment of Honorable Supreme Court. That is Sharat Babu Digumarti versus NCT, Sharat Babu Digumarti versus NCT 2016 Supreme Court of India. In this case, the co-accused Sharat Babu Digumarti also pleaded before the court that I am also liable to be free because company has not been made as an accused. But what happened in this case? Prosecution invoked section 292, 294 against Sharat Babu Digumarti. So that this matter was heard by Honorable Apex Court, and Honorable Apex Court clarified that 292, 294 is for offline content. In this case, the content was uploaded by way of using electronic form, and for electronic form we have already 67 IT Act. So here IT Act overrides General Act. So very important case study, kindly go through by this judgment. That is, first is the Baji.com case, second is the Sharat Babu Digumarti versus NCT 2016 Supreme Court of India. So in specific cases, IT Act is having the overriding fact. So we have covered three practical scenarios. First is the cyber crime, but it is only punishable under conventional law. There is no IT Act. Sub-inspector or any competent officer can investigate. Second category, we have the IPC and IT Act, where investigation has to be done by the inspector. And third category, we have where IT Act is having the overriding effect over IPC. So pertaining to cyber crimes, yeah, this can be against individuals. So we have morality crimes, we have monetary crimes. Monetary crimes because we have like financial crimes, like job fraud, like sympathy frauds. One case is very important case study that where a lady from down south received an email that she has won lottery of 45 lakhs. And as per instructions given on email, she invested 12 lakh rupees. and that the money has to be transferred to custom officer and other things and conversion money. And she flew to Delhi to get to get the money, that lottery money. And she came to know that it was a cyber crime. She came back to her place and committed suicide. So that is the dangerous aspect of cyber crime, you can say, in cyberspace, because as far as cyber criminology is concerned, the crime is committing by way of using cyberspace, but its impact is on physical space. So against individuals, we have sextortion cases like morality crimes. On the one side, we have monetary crimes against, and on the other side, we have sextortion cases. People are using WhatsApp video call. They are calling boy on girl. They instigate the other person to conduct something. They capture the private area part or any other sexual activity. Then after they start extorting that person, that victim. So we have these type of cases in our cyberspace. Second is the organization or state organizations or country, you can say, like attack on critical information infrastructure or servers, like network crimes. We will discuss 4 case studies also against society at large, like child pornography, cyber teasing, cyber stalking, cyber roasting. So these are some important cases where we have the society at large is completely targeted. So third part is against individuals, against organizations, society at large. So we have covered 3 parts, like target, like tool and a place of criminal activity, cybercrime IPC, cybercrime IPC IT Act, cybercrime IT Act overrides General Act. And we have 3 categories, like against the victim part, against individuals, against organizations, against society at large. What about the vulnerabilities? So more we are connected on the internet, more people are connected to the internet, more devices are connected to the internet, there are vulnerabilities. So there are so many chances of cyber crimes, you can say. So what about the vulnerability? Humans are vulnerable by way of psychological tricks, by way of social engineering tricks. People are calling us like they are updating our 3G to 4G. We are disseminating our information. We are compromising our OTP. We are providing our personal information, identifiable information, that is PII. So that is the important part. So what about the data never sleeps? You can say we are generating so many data. Data is a critical asset for us also and for the company. We are the data subject. The company's data controller or third party is the data processor, you can say. So we have some liabilities, we have some cross checks, like company has to comply with the IT rules. We have IT rules in IT Act also. So they have to comply with. The important part is the disclosure dilemma. They have been hacked, but they never disclose that they have been hacked, because in GDPR they have to pay so huge amount of like penalty and compensation. Here in India, we have the strong law, and I handled one case. I will discuss one case study of data protection law of India. So that's important. We are waiting for personal data protection bill, but still we have the robust law in IT Act and IT rules, you can say. So most important part is that further, if you go through by the case studies classification, so we have 4 categories of data crimes. So we have first is the data crime includes data interception, modification, data theft. Then I will cover up this case study with I skip this part and I will cover up with the case study. Network crime, somebody has attacked on my server, DOS attack, DDoS attack, disruption my services by way of enclosing, interfering with the functions of a computer network by inputting, transmitting, damaging, modifying or suppressing by way of computer contaminant, computer virus. You can say access crime, somebody is unauthorizedly accessing my system, devices, network, my database, was by way of violation of copyright, like typo squatting, cyber squatting. Somebody has opened like bisleri.com. Somebody has used a brand names and he has opened a domain name like abcchamber.com. He has got the domain abcchambers.com. Only as is different. Like ONGC, the criminals use OGNC. So this is known as typo squatting, like Microsoft, MICR, OSoft. The criminals use MICR, ZeroSoft. So we have so many things regarding these type of cases, like system optimization. You can say when we browse the like Microsoft, we open the window of MICR zerosoft.com because it is on the top size, you can say. So these are some important typo squatting, cyber squatting crimes. We have like cyber threatening, the cyber roasting, cyber bullying, cyber teasing, cyber roasting, and cyber bullying and stalking cases also. So first part is a very important case study I am having where my client is manufacturing a product. So he manufactured a product and then after he sold that product and sent to the like European client, like it was an FOB, freight on board. The foreign client received that product. And after inspecting, after getting all the specifications cleared, he sent an email that I have received this consignment and you can send an email, like you can send your invoice. So my client, by way of attachment of the bill, sent an email to that foreign client. It was intercepted. It is known as man in the middle attack. or we can say business email communication scam attack. So it was in transit, it was stopped. You can say it was the man in the middle attack. It was under surveillance. They stopped. You can say in transit. The mail was never received by the addressee. You can say they stopped in transit. They morphed that details, like it was the Delhi bank address, but they changed the bank address by way of morphing, and they changed the bank address and incorporated Bank of Australia details and send that email to foreign client. The foreign client received that email with a changed bank address, and the foreign client transferred 1 crore 30 lakh rupees to in Bank of Australia. When law enforcement agencies sent 91 CRPC notice, they replied come through by mutual legal assistant treaty. That is a cumbersome procedure. So zero investigation, zero recovery. So this is the very important challenges, which means hurdles, you can say, bottlenecks, you can say, like investigation abroad. We are facing so many challenges as far as these cases are concerned, like man in the middle attack or business email communication scam attack. So what is the difference between conventional crime and IT crimes? Yes, cyber crimes, here person is intruding by way of trespass. Here is person has intruded by way of using like devices and internet communication, computer network or communication network, you can say. I hope there was this connection.
Yes, sir. You're audible.
Yeah, so just I'm opening my PPT again. There is a problem. I hope it's visible, ma'am.
Yes, so PPT is visible. Yes, sir.
Yeah, visible. Okay, thank you. Sorry.
Yes,
So now, what type of cases we are having in cyberspace, like phishing emails? So very important case study is the Cosmos Bank case. So Cosmos Bank, what happened? It was a targeted attack in 2017. They sent an spear phishing mail. What is spear phishing mail? They targeted one organization. They identified the vulnerability, like we can say the scanning. Then they accessed complete database. So first they sent a spear phishing mail to the Cosmos Bank Maharashtra. One of the bank branches downloaded that detail attachment, and the payload was transferred into the system and is spread it over to all means you can say branches. And they were capable to get access all debit card, credit card, PIN numbers of our like citizens of India. And in 2018, after 1 year, on 11th August, 13th August, they it was a largest targeted attack, you can say, and they siphoned off 94 crore rupees of Cosmos Bank Maharashtra by way of using 450 clone cards in 28 countries. So Maharashtra police did a commendable job. They have arrested. They have filed 3 supplementary charge sheet in this case, and the government of India has also initiated one extradition treaty of 3 people through by way of Dubai extradition agreement we have. So that is phishing email. Like we have spoofing cases. Somebody can use your email ID to send an email to me, or my email ID can be used to send an email to you. My mobile number can be used to call to you. This system devices can be used to send you any type of email also. So that is spoofing. Like social engineering attacks, like sympathy frauds, job frauds. We have malware system like computer contaminant. So what type of cases we have, like what sections we can invoke? So we will discuss 6643C for malware part. What about unpatched vulnerabilities like zero-day attack? Before we don't have like our means you can say our antivirus cannot detect these type of threats because it's a zero-day attack. That's the important part. Delivery of malicious code. How to identify that there is any malicious code in my system. So suppose you have received an phishing email. So what to do? Before running that phishing email, or by way of clicking that email, you can copy that link. You can go through by virusfilter.com. You can check that whether it is a malicious link or not. So yes, Again, what about the encryption part? Whether we have completely encrypted or whether we are using BitLocker in our system or not, like brute force attack. What about the password attacks we have? We have dictionary attack, brute force attack. What type of strong password we have? Then DOS attack. Companies are all scared about how DDoS attack or DOS attack for server issues. Like we have section 43F of IT Act we have covered. We will cover. Then compromised credentials. Our personal information is being compromised. Our source code is compromised. Our data is compromised. Then malicious insiders. This is the dangerous part. Our disgruntled employee is using our database and he's transferring or selling our content, or he has started his own business by way of after leaving that company. So this is the important part. And man in the middle, we have already covered, like in foreign client case. Now we have very important part. Who are these cyber criminals? Like state countries are involved. Insider threat is there. Conventional criminals are now using sophisticated technology. They know about how to commit these type of crimes. So they are using these type of skip kiddies, like minors are also involved. Like in all the cases like sextortion, we have 9 to 11 hotbeds in India, like in Mewar, whole village, 70% of villagers are involved in these type of sextortion cases in like Bharatpur part and some remote area part of Bharatpur and a remote area part of like Jamtara also. So what about the reasons of crime? Because they can mask their identity. They know that they can means bypass the security, and they use the money mules. They are using duplicate SIM cards issued by telecom companies by way of providing forged ID cards, you can say. What about the law in India? We have the IT Act. We have IT Act Amendment 2010, and the most important part, the Supreme Court has provided us that right to privacy as a fundamental right in justice for transformative judgment. So what about the compliances and law? Yes, we have IT Act. We have 13 chapters, 90 sections, and IT Act is effective from 17th October 2000. We have then there are between 17th October 2000 to, you can say, Mumbai attack. We had so many LPO cases, BPOs cases, KPOs cases, data breach, data privacy issues. And after Mumbai attack, within 40 days, IT Act was amended. The focus was data privacy, information security, cyber cafe rules, because in most of the cases, bomb blast cases like Pune, Bangalore, Bhopal, Jaipur, and Bombay, and Ahmedabad, the criminals were using cyber cafe. We didn't have any cyber cafe rules, but now we have cyber cafe rules. They have to preserve 1-year database. So that's the most important part. The important part is the redefining the role of intermediaries in India. What about we have intermediary rules 2021. Earlier we had the intermediary rules 2011. They have to comply with. We have sensitive personal data information rules we have, so they have to comply with the SPDI rules also. So how your personal information is being used or shared with other. What about the data subject? What is the data controller? Who is accessing your database? What about disclosure? What about right to rectification? What about right to eraser or means right to be forgotten? Yeah, we have in means 2011 rules we have. So how your personal information is protected? Who would be accountable for its misuse? So we have in IT Act in these type of cases, you can say. We will discuss one very important case study. So structure of IT Act, we can divide into 13 chapters. We have 90 sections. We can divide into 5 parts, like e-commerce, we have e-governance, we have electronic crime cases where we have cyber contraventions, and adjudication part also cyber offenses. We have data privacy cases, section 70 to 72A, we have 43 capital A, we have, then we have e-security like certain. And some guidelines government has recently issued on 28 April that every body corporate, even government organizations have to comply with certain guidelines. If there is any cyber security incident, they have to inform within 6 hours. They have to preserve maintain the logs for VPN, virtual private networks for 5 years. That's the most important thing government has done. Now we have some rules in IT Act. So near about 90 to 20 rules, we have very important rules if we go through by. So I will cover very important part, that is Information Technology Guidelines and Digital Media Ethics Code 2021. So where means law enforcement agencies are now empowered to track criminals, and these intermediaries are liable to provide information as far as these cyber criminals are concerned. So yes, recently government has issued certain guidelines 28 for 2022. So they have to maintain what about the point of contacts, like they have to connect to the network protocol server of the national informatics, like they have to enable logs of ICT for 180 days, you can say. And we have covered the VPN part, virtual private networks. So they have to, who is the user, what about his credentials and details. So they preserve one for 5 years. Very important rules regulations. So we have. What about the applicability of Act 8? So it is applicable to whole of India. Section 1 subsection 2 clarifies it is applicable to whole of India, and it is known as like territorial jurisdiction. We have the extraterritorial jurisdiction also in section 75. It has been clarified. So if there is any offense contraventions happened in India, but computer system network is located in India and somebody is from outside, like my system is now in Delhi and somebody from Nigeria has hacked my system which is in Delhi, ITACT is applicable to Nigeria also. Till we have MLET, we have extradition treaties, we have LOR through which honorable courts can issue order like under section 166A. But if my system is located in Russia, somebody from Nigeria hacked my system which is located in Russia, ITACT is not applicable. So section 1 subsection 2 territorial jurisdiction and section 75 is extraterritorial jurisdiction. Non-applicability, yes, on sale deeds, on trust, on negotiable instrument other than check, it is not applicable. On documents like trust deed and like power attorney, sale transaction documents, ITACT is not applicable. Overriding fact, section 81 we have covered with Sharad Babu Digumurthy versus NCT 2016 judgment. So very important definitions we have. What about the access addressee? Who is addressee? So I sent content to ma'am. Ma'am is the addressee. I am the originator. I have used communication device. Which communication device I have used? What about the IMI number? What about the MAC address? This is the most important part to prove before the court which devices have been used, which communication network was being used. Suppose I am using another person's communication device. I have unauthorizedly accessed his communication device. And I've used his internet. So that's the most important part. What about the computer network? What about the computer resource? That's the most important definition, which covers almost everything. You can say computer resource means computer system, computer network, data, computer database, or software. So the most important definition. Then we have computer system. And most important part is we can divide IT Act into two parts also. We have two remedies, criminal part also and civil parts, like Motor Vehicle Act, like defamation part. So we have in IT Act cyber contraventions and cyber offenses. So what about cyber contravention? Refers to a civil wrong like in cyber torts, or you can say tort law. It is important to note that law of torts provides remedies for civil wrong where affected person can compel the wrongdoer to pay damages by way of compensation. So IT Act is having section 43. We have 10 subsections, 43 A, B, C, D, E, F, G, H, I, J. So 43 A to J are known as cyber contraventions. So if somebody has done any act referred in section 43 A, B, C, D, E, F, G, H, I, J, and I have suffered loss up to 5 CR. So where I have to go? I have to go before the principal IT secretary of the state. So suppose I am in Rajasthan. So means where I have to go if I have suffered loss up to 5 CR. Up to 5 CR, civil courts are barred. Section 61 bars. So civil courts are barred up to 5 CR. I cannot go before the honorable civil courts to file a money recovery suit. Sorry, up to 5 CR, I have to file a case before the principal IT secretary of the state, who is having the power under section 46, 47 and IT adjudicator. So up to 5 CR, he can adjudicate, he can compensate me, and more than 5 CR to unlimited, I have to file a case before the civil court jurisdiction. That's an important part. So this is known as the cyber contraventions. What about the hierarchy? Means yes, after IT secretary, within 45 days, suppose I have filed a case before the principal IT secretary of the Rajasthan. I won this case. The losing party can appeal before the TD SAT in Delhi within 45 days. After TD SAT, within 60 days to Rajasthan High Court, it depends Jaipur bench or Jodhpur bench. Then after Honorable Supreme Court. So this is the important part regarding these type of adjudication part. What about these section? This section 66, 43 A, B, C, D, E, F, G, H, I, J. This is cyber contravention. When it becomes cyber offense. So the most important part is the section 43, 10 subsections, and this is the more important part. So these are cyber contravention 43 A to J. If somebody has done any act referred in section 43 A to J with dishonest or fraudulent intention, now it becomes section 66 IT Act cyber offense. So for 66, it is 66 read with 43 A, B, C, D, E, F, G, H, I, J. So important criminal section is 66 read with 43 A, B, C, D, E, F, G, H, I, J. So we can initiate two proceedings. We can go before the file a complaint before the principal IT secretary to get compensation. We can also lodge an FIR against that criminal against section 66 read with that particular 43 A, B, C, D, E, F, G, H, I, J. So what about 43 complete section? So section 43 says, if any person without permission of the owner or in charge of a computer system network, suppose I am the owner of this system, my associate lawyer is in charge of this computer system network, and somebody came to my office, he access or secure access to this computer. Physically, he accessed my system. and he accessed my database, or you can say my startup product, or my means bidding amount which I am going to file for a tender. So he accessed my system, that is known as section 6643 small a. So because dishonestly he has accessed my system because his intention was bad, or suppose he without criminal intention he accessed my system, but he got access and now he is aware about my means IPR part or any trade secret. So I can file a case before the Principal IT Secretary of the state under section 43 small a. And if there is any criminal intent, so 66 read with 43 small a is the unauthorized access. So somebody unauthorizedly access my system is the important section is 6643 small a. Somebody has hacked my system. So it covers both physical access or remote access. So physically he has accessed my system, or remotely he has accessed my system by way of hacking, by way of any type of virtual hacking, virtual access he is having. So the important section is 66 read with 43A. Somebody has downloaded, copy, extract my database. Somebody came to my office, he accessed my system by way of control P, he got some printouts. By way of inserting one pen drive, he got some database. By way of sending this means using this device and uploading on Google Drive, and or by way of using Bluetooth, he has transferred some database. So any type of copying by way of mobile, he has taken this snapshot. So any type of copying, downloading, extracting is covered under section 6643B. Data theft, you can say. So again, I can file a case before the Principal IT Secretary for unauthorized access and for data theft 43A, and lodge an FIR against that person 6643A, 43B IT Act. 43C says covers like any type of ransomware attack or any type of phishing link I have received, and by way of that my system got compromised. So any type of computer contaminant of virus by way of physical, he has inserted one pen drive. By way of pen drive, my system got compromised. So it's a physical intrusion, you can see, or somebody has sent me a link. I click that link, my system got compromised. Now spyware, stalkware, or any type of malware are in my system. Keyloggers are in my system. That is 6643C. And by way of that computer contaminant, my system got compromised. My database has been damaged. They have encrypted my database. They have disabled my devices. That is known as section 66 read with 43D, damage computer database or any other program in such system. They have disrupted any type of disruption, any type of email bombing case. They have sent so many emails, so my server has been now crashed, you can say. That is disruption, section 43E. Any type of disruption activities on my server or network, that is 43E. Then very important case is the DOS attack, denial of service attack. Suppose we are unable to access our High Court website. Somebody has like attacked by way of DOS attack, by way of DDoS attack. So they have completely attacked on our High Court website. We are unable to access the cause list and the case status. So it means somebody has attacked by way of DOS attack, by way of DDoS attack. That is known as 6643F. We are legitimately unable to access our website, that is, or our system. Then very important section is to provide assistance to facilitate access to legal access. Somebody in my office is unauthorizedly providing my system access to third-party company. Suppose my disgruntled employee has provided access to my computer company, my system, like remotely he is now accessed. So a very important case, what happened where a IT professional requested HR that I kindly increase my salary. So HR replied that due to pandemic, we cannot increase your salary because we have to restructure every means like employee means we have to increase. So he was annoyed, and what he did, he sent an email, like a resignation email. It was duly accepted, and immediately the IT team disabled his complete access. He was only allowed for limited access. So what he did, he was trying to access database. He was trying to get all complete database, but he was disallowed by the IT team, IT system. So what he did, he requested one of the co-employees that kindly help me out. I am joining a very good company down south, and I will absorb you with 40% increment. The gentleman was compromised, and he provided remote access to that person. By way of that remote access, he got database. So the person who provided access is booked under section 43 GIT Act. That very important section is the 43H. Somebody is using your services. Somebody has used your credit card. Somebody is hacked your system, is using your Wi-Fi, downloaded everything. So somebody has compromised your system. Somebody is using your services, and you are paying for that service like credit card and other things. So that is well covered under section 43H. Now section 43I is data diddling by way of any type of alteration. So very important case study, Sanjay Kumar versus State of Haryana. Honorable Judge Haryana High Court held the trial court judgment, where in this case bank employed IT professionals for in on annual maintenance charges, you can say, and they were taking care of complete systems of banks. So what that person did, he opened the bank account, a saving account in that bank, and he manipulated two entries, 44 lakh entry and 40 lakh entry, and he transferred 7 lakh rupees to his saving account. Then after IT audit came and they identified that there is some tampering and manipulation. So that person was booked under section 66 read with 43I and also 65 ITI, that is known as tampering with computer source documents. So both two sections were invoked against that person, 66 43I and 65 ITI. So again, in this case, we can file a compensation case before principal IT secretary and we can lodge an FIR before concerned police station. So criminal case and also civil case. And I'm handling, as a lawyer, I am handling so many cases regarding source code case, that is section 66 read with 43J. In Chandigarh also we have cases in Dehradun, in Jaipur, in Pune, and Bangalore and Hyderabad also, like stealing, concealing, destroying, or altering any computer source code. Suppose one IT professional is working with my company and he has stolen my source code and he has started his own business by way of using my source code or by way of altered version. So that is a clear case of 6643J, also 408 IPC also, because criminal breach of trust by employee. So here we can invoke both IPC and IT. So any type of cases regarding as far as stealing, concealing, destroying, or altering any source code, that is 6643J. I can also file a complaint before the principal IT secretary for the damage which I have suffered against that ex-employee, you can say. So here we have covered section 43. We have 10 subsections. We have covered unauthorized access, hacking 43A, B is data theft, C is virus, D is damage, E disruption, F DOS attack, G provide assistance like abatement, then charges a service and somebody is using my services, then I is data diddling, J is source code. So here we can go before the principal IT secretary for compensation and we can lodge a FIR against that person under section 66 IT Act, that is cyber offense. So any person who has done any act referred in section 43A to J with this one is fraudulent intention, that is 66. But prosecution has to prove that this act was done by way of criminal intention. Suppose he negligently accessed my system, so he is liable under section civil part also. So now we have very important section as far as data protection law is concerned. So yes, 43 capital is compensation for failure to protect data. So any body corporate like banks, telecom companies, insurance companies, or you can say crypto exchanges who are maintaining our database, like we are data subject and they are the controller or they are data processor. If they fail to comply, if they fail to protect my database and they have compromised or they have breached or they have, sorry, means they have disclosed our database or they have like, so they are liable under section 43 capital A for compensation up to 5 CR before the principal IT secretary and more than 5 CR to unlimited before honorable civil courts. So we have to be means very careful regarding these companies we have to be very careful regarding compliance of 43A and also rules the information technology reasonable security practices and procedures sensitive procedure information 2011. So they have to be careful regarding ISO certification 27001. What about the security controls they have? So very important case study I handled where my client's mobile SIM was deactivated and it was and again next day they provided new duplicate SIM card, but for 5 days it was deactivated. When he approached the bank, he came to know that his that the 68 lakhs 50,000 have been siphoned off within 5 days. So I opposed the bail before the Honorable JM First Class, then Honorable ADJ, then Honorable High Court, and we opposed the bail of 4 accused and Honorable, thanks to Honorable Court also, they never granted the bail and when accused requested before the court that I am willing to pay the money back, then after they got the bail and we recovered 44 lakh rupees from 4 accused. And one of the accused was behind the bar for 3 years, 2 months, and he got the default bail. But meanwhile, I filed the first case in Rajasthan under section 43A before the principal IT secretary of the Rajasthan under section 43A against telecom company who issued the duplicate SIM card to cyber criminals. So out of 68 lakhs 50,000, we recovered 44 lakhs from the accused. Then after they got the bail, and regarding remaining 24 lakhs 50,000, I filed the case before the principal IT secretary of Rajasthan. We got the order against the telecom company and honorable court, honorable learned IG means IT adjudicator awarded 27 lakhs 53,000 compensation to my victim complainant. And now telecom company has filed a case appeal before the TD set and we are waiting for the final hearing. So this is the important case study. So we have to be we have to make people aware also that we have the compensation part in IT Act also. So we can approach before the principal IT secretary up to 5 CR if there is any hacking, if there is any compromise of our data breach. So yes, we have IT adjudication part also, and more than 5 CR up to limited we can go before the honorable civil courts. That is 43A. Pertaining to 72A, like if there is any criminal intention by any company, so knowingly and with intent, so we can means book that company under section 72A, criminal prosecution of that company. So if we want to prosecute any company, we have to invoke section 85 also, that is offense by companies. Now, what about cyber IT Act offenses? So we have section 65, tampering with computer source documents. So a person who was supposed to safeguard that computer source document, but he concealed, he destroyed, he altered that computer source code when the law says you have to keep that source code as it is, but he himself concealed, or by way of another person's he concealed, destroyed, or altered that computer source code. That we have covered that judgment also, Sanjay Kumar, that person was booked also under section 65. As far as IMI number is concerned, so very important case study is the Syed Asafuddin versus state of Andhra Pradesh. Syed Asafuddin versus state of Andhra Pradesh, where ESN number of CDMA phone was changed, you can say tempered. And the accused was booked under section 65 and 63 of Copyright Act also. Now for changing of IMI number of mobile phone, suppose somebody has changed mobile's IMI number, it's like jailbreaking, you can say. So we have section 25 Indian Telegraph Act 1885. So we can book that criminal under section 25 Indian Telegraph Act for tampering with IMI number. So 65 is bailable, cognizable, and punishment is up to 3 years. Computer related offense 66 we have covered. It is bailable, cognizable, and punishment is up to 3 years. 66B is like 411 IPC. So dishonestly receiving stolen computer resource or communication device. So what is computer resource? Computer system, computer network, data, database, software. So somebody came to my office, he accessed system by way of pen drive, he got some database and he sold the database to third company. The third company who dishonestly received that stolen database is booked under section 66B. So receiving or means knowingly receiving stolen database or communication device, the section 66B is bailable, cognizable, and punishment is up to 3 years. Now, identity theft, somebody is using my PIN number, my OTP, my unique identity, my biometrics, my voice also. Voice can also be cloned by way of softwares having in open source also. So somebody is using my voice or my unique identity, that is 66C, that is bailable, cognizable, and punishment up to 3 years. Like somebody hacked my Gmail account. So it means he has unauthorizedly accessed my Gmail. He has unauthorizedly used my unique identity, that is user ID, that is 6643A for hacking, and using identity theft is using my identity is 66C. So 6643 small a and 66C is the proper section. What about cheating by personation by using computer resource? So all phishing, wishing, smishing cases, spoofing cases, somebody can call me that I am calling from this telecom company, I am updating your 3G to 4G, I am providing eSIM, or I am connecting your PAN to Aadhaar. All these type of cases are covered under section 66D or 419 IPC also. It depends what type of documents they have exchanged, or if there is any documentation, forged document has been shared and he has signed and uploaded that content also. That is 468 IPC also. So it's a combination of IPC and IT Act also. Then it's bailable offense and cognizable, and punishment is up to 3 years. Then violation of body privacy. So yes, these are some very important case studies where we have seen law enforcement agencies are not invoking these sections, like 66E, like sextortion cases. Suppose somebody has captured my private area part without my consent, that is 66E. Suppose I've given the consent, but he uploaded that content on WhatsApp or Facebook, that is 66E. So capturing, publishing, transmitting any private area part of any person, it covers both male and female. So female can also be liable, or male can also be liable if they have captured or transmit or published without consent. So for capturing, it was consent, but the other person has uploaded, he is also liable. For sextortion, for gang rape cases, hidden camera in hotel rooms. So all cases are covered under section 66E, but it's bailable, cognizable, and punishment up to 3 years. Cyber terrorism is the most dangerous crime, you can say, because it can be against country, it can be against society at large, to strike terror in the community or to against nation's integrity, sovereignty of India. But by way of DOS attack, we have covered 43F. By way of unauthorized access, penetration or attempt to hack, that is 43A, and by way of like computer contaminant virus attack, 43C. So by way of DOS attack, by way of unauthorized access, hacking, or by way of computer contaminant attack, if somebody has attacked on the national security integrity of India or to strike terror on the people and to cause death or to disrupt any essential services, adversely affect the critical information infrastructure which has been declared as protected system under Section 70, or any type of information which has been restricted for public access. Somebody unauthorizedly accessed that information, or the person who was authorized to access, but he exceeded his authority. Suppose he's a scientist in that department, but he exceeded his authority and he disclosed that information for foreign national group, you can say, or to take advantage of any country. So that is well covered under Section 66F, or you can say read with. You can also cover Official Secret Act, and the punishment is up to life imprisonment, non-bailable, cognizable offence. So 66F is very important. There was a very important case where a activist uploaded an YouTube video to eradicate the manual scavenging. So in that case, 66F was being misused, and Honorable High Court strictly objected how these type of things are doing, means like how law enforcement agencies using this section because she genuinely she uploaded that content to eradicate manual scavenging from the society. So it doesn't attract Section 66F IT Act. Now, very important, three sections we have: 67, 67A and 67B, that is obscenity. So publishing or transmitting obscene material in electronic form. So if somebody has transmitted or published any obscene content in electronic form, that is 67 IT. But most important part, three words: lascivious, prurient interest, tend to deprave. So any type of content which can be heard, seen, or read, means anybody can read that content. If I have sent you a message, you can read that message. If I've sent an obscene content photograph, you can see that content. If I've sent an audio file, you can hear that that content, you can say that audio file. So read, see, or hear any type of content which is lascivious, means if there is any lustful excitement. So that type of content covers under Section 67. If I have abused on Facebook, that will cover 504. For abusing, that is not covered. But yes, any type of lustful excitement, lustful content, if I have published or have posted, that is Section 67 item, that is bailable, cognizable, and punishment is up to 3 years. And in this section, there is no mens rea. So means defense cannot raise the objection before the court, or cannot take plea that I was not having the intention. Oh, he can take plea that I have never sent this content. My system was compromised. Somebody has used my system as a tool, or my phone was unattended at the time when somebody has used that my phone. But he cannot take plea that I was not having intention, because in this section there is no intention. If somebody has uploaded, transmitted, published, he is liable under Section 67 IT Act. Same for 67A, there is no intention part. Same for 67B, there is no intention part. 67A is sexual explicit content like porn. Porn is not defined in IT Act, but any type of sexual explicit content, which is porn content, if any person has uploaded or transmitted or published that content, that is 67A. Same for sextortion cases. For sextortion, somebody called A called B, and B has done some conduct by way of using, like we can say it's a masturbation content, and it has been captured by way of sex, and that screen recording, and then after they send this content to that victim and they started extortion. So that masturbation content is well covered under Section 67A, that is non-bailable. It is not obscene, it's in higher degree, you can say. So that is 67A, non-bailable. So we have seen so many cases where sextortion cases, they have used only 67A obscene content, but masturbation is well covered under Section 67A, non-bailable. And 67B is again, yes, child pornography is defined in POCSO Act, but it also covers, like in 67B, but it also covers 3 parts also. So punishment for publishing, transmitting material depicting children in sexually explicit act in electronic form, and 3 parts also: sexually explicit, obscene, and indecent. So it covers 3 things: obscene content of minor, indecent content of minor, and sexually explicit of minor. So it covers 3 things. Or any type of sextortion, 67BE part, any type of sextortion, somebody is recording, monitoring remotely in my minor's private area part, that is also 67B. IT Act and POCSO also. So that is non-bailable offence, cognizable, and punishment is up to 5 years and subsequent 7 years, and 10 lakhs fine is there. So in these type of cases, very important part, prosecution has to be careful. If there is any section, I mean, like if there is any application filed before the Honorable Court under Section 207 to get image copy or pen drive of or image copy of hard drive from prosecution. So suppose I filed a 207 application before Honorable Court, you kindly provide image copy of this content. So any type of content where it attracts, like there is an privacy violation, you can say gang rape, obscene child porn content, or hidden camera content, or sexual explicit content, court will only allow for inspection. Court will never allow to give image copy. In other cases, It's a statutory right of defense to get all documents on which because prosecution is relying. Even recently, Honorable Supreme Court also clarified on the documents which IO has not relied, they have to provide these documents. But in these type of cases, defense only is having only inspection right, and if there is any objection raised before the court, yes, defense can also bring an IT expert before the court. If there is any objection raised before the court, yes, court is having the result that court can seek an expert opinion under section 45A of Indian Evidence Act. Read with section 79A of IT Act, that is mighty. The Ministry of Electronics Information Technology has declared till today 10 forensic labs have been declared as EEE, examiner of electronic evidence. So when in a proceeding, so 45A says that when in a proceeding, if there is any issue regarding like any type of electronic form of evidence, if court wants to get the expert opinion under section 45A, so on court can only ask for expert opinion from these labs which have been notified under section 79A by MITI. So we have 5 labs in Delhi, MITI like Roni Forensic Lab, certain Delhi, SFIO Delhi, Army Cyber Group and Air Force Cyber Group, and we have Gujarat Forensic Lab, Kerala Forensic Lab, Bangalore Forensic Lab, CFSL Hyderabad and Himachal Pradesh Dharamshala. So we have 10 labs which have been notified under section 79A as EEE. So that this is very important. And judgment is the P. Gopal Krishnan alias Dilip versus State of Kerala 2019, where court has clarified, yes, under 207 we cannot provide these type of image copies, but yes, you have right to inspect before the court. P. Gopal Krishnan alias Dilip versus State of Kerala 2019. Now we have section 67C, preservation retention of information by intermediaries. Yes, central government is empowered to issue directions to intermediaries, telecom companies to preserve electronic record for 2 years, 3 years, like in recently after compliance of Honorable Supreme Court's Arjun Pandit Rao judgment, central government has issued directions to telecom companies to preserve, retain IPDR, CDR for 2 years, like in matrimonial websites, we have 1 year, like in cyber cafe, we have 1 year. So if they fail to comply, they are liable for 3 years imprisonment, bailable, cognizable offence. Then we have interception law. Yes, we have interception in Telegraph Act also. We have interception in IG Act also for internet, for interception of computer source and blocking. We have 69A, and for collecting traffic data, we have section 69B. So yes, interception, we have to follow 419A rules regarding the protocol which have been defined in Telegraph Act and Telegraph Rules 419A, same we are adopting. So we have 2009 rules also regarding interception part on IT Act. So yes, central government and state governments are empowered to issue directions to intercept, and if the intermediary fail to comply with, they are liable for 7 years imprisonment, that is non-bailable offence. Power to issue directions for blocking for public access. Yes, honorable courts and central government is empowered to block any type of content from public access, like Honorable Uttarakhand issued directions for blocking of more than 780 porn websites. Recently, central government banned some Chinese apps also, and Ministry of Information Broadcasting also banned some YouTube channels under section 69A. And 69B for cyber security purpose, central government is empowered to collect, monitor traffic data. If they fail to comply, they are liable for 3 years imprisonment. Then section 70, unauthorized access to protect the system. Central government and state government has declared any computer resource for national security, privacy, or like economy as a protected system. If somebody hacks or attempts to hack that protected system, he is liable under section 70 for 10 years imprisonment. Now we have certain guidelines we have covered, like from 28/4/2022. Now it will be effective after 2 months. That we are waiting for that effectiveness, you can say. And breach of confidentiality and privacy, section 72. So any person, any officer who is authorizedly, bona fidely has accessed my system, he took some database information from electronic record from my system, but he disclosed that information to third party without my consent, he is liable under section 72 for 2 years. That's a non-cognizable bailable offense. 72A we have covered, like companies, telecom companies, bank who fail to comply and who knowingly or with intent to cause me wrongful loss, they disclose my database, so they are liable also under criminal prosecution. That's section 72A, and civil part is 43 capital A. We have covered the same case study. Now we have 74, publication of fraudulent purpose, means somebody is using his digital signature for fraudulent purpose. He is liable for 2 years imprisonment. Section 75, extraterritorial jurisdiction, we have covered. Compounding of offences, IT Act offences up to 3 years. All IT Act offences are compoundable by courts. More than 3 years are not compoundable, provided that court shall not compound any IT Act offence which is against women, minor, and it is against socio-economic conditions of the country. Suppose somebody has hacked me, so I can get compromised or compoundable before the court. Okay, no issue, sir. But somebody has hacked the bank, against it is socio-economic condition of the country, against women, against minor, court shall not compound under section 77A. What about 77B? Up to 3 years, all IT Act offences are bailable. More than 3 years are non-bailable offence. 3 years and more than 3 years are cognizable offence. So 65 is bailable cognizable, 66 is bailable cognizable, 66A is declared as unconstitutional, 66B is bailable cognizable, 66C is bailable cognizable, D is bailable cognizable, E is bailable cognizable, F is non-bailable cognizable, 67 is bailable cognizable, 67A pawn content non-bailable cognizable, 67C bailable cognizable, 69 interception non-bailable cognizable, 69A blocking non-bailable cognizable, then 69B is bailable cognizable, 70 non-bailable cognizable, 72A is bailable cognizable. Now, very important, section 79, exemption from liability of intermediary in certain cases. Read with intermediary rules, now rules 2021, earlier it was 2011. So in any case where there is a role of intermediary, obviously we are all using ISPs, intermediaries. So if they are directly involved, if they have instigated, they have conspired, or they are abetted, they have provided platform for unlawful activities, so they are liable. If they have complying, if they have done all due diligence and they are before the courts or before the authorities that we have complied with all rules, regulations, we have complied the central government's honorable courts or orders, then they are free, they are exempted from the liability. But in our case, like in my case, the telecom company objected before the honorable IT secretary that we have complied and we are exempted because we are the intermediary. But we objected before the honorable IT secretary that they didn't comply because there is a rule that of DOT rules that original subscriber must be present when duplicate SIM card is being issued. So in our case, criminals got that duplicate SIM card, not our owner. So in this case, they failed to comply. The central government notifications, they are not exempted under IT Act. So that's the section 79 that is known as safe harbor law. So immunity versus liability. So they are immune if they have complied with the guidelines or notifications, if they themselves, or a very important part, that is section 79(3)(b). So 79(3)(b), after Shia Singhal versus Union of India, honorable court clarified by way of court order or by way of law enforcement agency's order, if they have to comply with the 79(3)(b) notice, which is known as takedown notice. After receiving that notice, they have to remove or disable that content which is published on their system. If they fail to comply, so yes, we can book that company or intermediary under relevant provision, that is 84B or 85 of IT Act. 84B is abatement of that content or abatement of any offense. That's and 85 is offense by companies. Now 80 is 79A we have covered. 79A is means examiner of electronic evidence. 10 forensic labs have been declared as EEE, examiner of electronic evidence. Punishment for abatement of offense. So if anybody has provided flashers or like IMI number change software, so somebody is providing ethical hacking or sort of including, somebody has installed a hidden camera in a hotel room, so is an abetting part. And punishment for attempt to commit offense. Somebody has tried to hack my Gmail account, but I am using two-factor authentication. I didn't click that okay allowing. Then so he did a attempt to means hack my system. So we have the failed login ID IP details. So we can law enforcement can ask Google Gmail the failed login ID like IP address. So we can track that criminal also by way of MAC address, mobile, or which device he was used, or what was the IP address. So yes, we can track these criminals and they can be booked under section 6643A for hacking and using my identity, that is 66C, and 84C is the attempt. And lastly, 85 offense by companies. So companies are liable if there is any liability, we can book that company under section 85 also with the relevant sections. So we have covered the IT Act part, and now the most important part, right to privacy and accuse. So yes, Justice Putraswamy judgment, we have very important law, that is fundamental right. Right to privacy is a fundamental right, but right to privacy is not an absolute right. So very important landmark judgment by Virendra Khanna case in the state of Karnataka, where court has clarified, yes, data privacy is very important law. It is a fundamental right. But what about the right to privacy for accused, you can say? So honorable court clarified, yes, right to privacy of accused is the data. Yes, it's a privacy right, but polygraphic test without consent is self-incrimination. IO has no right to disclose the private data seized from the smartphones or electronic gadgets of an accused to a third party without the written permission of the concerned court. So he cannot disclose my database to third party without the concerned court's permission. Honorable court lay down the procedure for examining smartphone. Suppose accused is not providing the password to law enforcement agency. He's not providing the email password, or he's not providing the like cryptocurrency, like wallet password. So what law enforcement agency can do? Yes, the court has clarified some points, very important part. So I can summarize in one important part. So what he can do, like law enforcement agencies has to file an application before the court for search warrant. So approach the court to seek a search warrant to search the smartphone and email. Sir, we are unable to search his email because he is not providing password. So they have to file an application before the court to get the search warrant to open that smartphone or to get his email ID password or to access his email ID. So if he has provided the password, that's good. Once a search warrant is issued, it's up to the petitioner accused to provide the password biometrics. Suppose he is not provided after issuing of the search warrant, then adverse inference notice is there. So notice to accused indicating that in the event of accused not furnishing the said password, biometrics, and adverse inference notice would be drawn against the accused as regards the aspects notified in the said notice. So afterwards, they have to issue the adverse inference notice to accused. Notice to service provider. Then after he has not given the password. In the event of accused or another person not providing the password, passcode, or biometrics on an application made by the prosecution, the court could direct the provider, like iPhone, open this password, or Gmail, kindly provide the password, but they didn't reply, they didn't open. So now court has clarified that again you have to file an application before the court. In the event of the manufacturer and the service provider not facilitating the opening of the smartphone's email account or computer equipment, then the court on an application being filed in that regard permit the investigating officer to hack into the smartphone or email account. It's like search warrant. We are going to open the house, but there is a lock. So we can request a duplicate key maker to open that lock. Same court has allowed to hack that phone. Then after court has clarified that okay, to take assistance, the investigating agency would be empowered to take empowered to engage the services of the such persons as may be required to hack into the smartphone. And then after court has clarified that relying upon the adverse inference. So in the event of the investigating agency is unsuccessful in hacking into the smartphone and on the email account, and during the course of such procedure, if the data on the smartphone or email account being destroyed, then the investigating agency or prosecution would be free to rely upon the notice by which the accused was warned of adverse inference being drawn. So very important case study. I request you all please go through by the judgment. Honorable court was also clarified if they got the password, then after they can change the password. Suppose somebody from remotely can access his email ID, he can delete or he can damage any type of tamper any type of database, you can say. So honorable court has also clarified that law enforcement agency successfully they got the password, then after they can change the password of that email or mobile phones. So court has covered this very important part in Viren Khanna versus State of Karnataka. And lastly, very important part is the stay safe and browse safe. So we all are netizens in the cyberspace. So yes, we have to be very careful because we are on the internet. We are using internet. Our devices are not safe. You can say even psychologically we are not safe. We can provide our OTP. We can be very easily hacked by way of emotional or by way of sympathetic frauds, we can say. So we have to be careful by way of using these type of internet activities or by way of browsing websites or by way of using these type of devices. So I hope I have covered IT Act within a time limit given to me, 11:12. Now I am open for question answer session, sir.
Yes, sir. Thank you very much. So we have received questions, and earlier in the registration form we have received very pertinent questions with regard to your topic. One of the questions that we received was, what do you think that there should be exclusive court to deal with cyber crimes only for the state?
Yes, that's great, and I hope means as far as information is concerned, yes. Means honorable courts, honorable like judges are also working on this part also. Like we have POXO court, like we have negotiable instrument act courts, we have like fake currency courts, okay, notes courts. So for cyber domain, yes, we require special courts for this part, and we require special public prosecutors for these things because they have to be careful about the understanding of cyber crimes and technology because they are representing a state before courts. Because nowadays, if defense is strong, they can easily dilute the matter. So that's the important part. Yes.
Yes, sir. So there's another question that we got, that what challenges are we going to face with new emerging technologies like quantum computing and artificial intelligence, and recently we have seen a case of metaverse also. So what challenges are going to be there for us to face?
Yeah, very good question, because I am also working on it. I am also pursuing PhD from IIT Delhi in this part, like challenges regarding regulatory part and the technology evolving technology, you can say. So yeah, like metaverse, we don't have any law, but yes, still we can drag the person under IPC. We don't have any section in IIT Act, but if any platform, if any intermediaries providing these platform for unlawful activities, yes, we can take it down by way of using 79(3)(b) or 84(b) of abatement of IIT Act, 85 offense by companies. So yes, we have regulations to control these type of things, activities government means doing by these intermediaries. As far as IoT is concerned, yes, the challenge is very dangerous, you can say, because more devices are connected with the internet, more vulnerability are there. Like Internet of Things, if I'm using my voice by way of means by open, I'm using my voice to open my mobile phone, and I'm using my voice to open my smart home, like main gate, and somebody has cloned my voice. So by way of IoT devices, he can, from remote place, he can open my gate anytime. So this is the dangerous part by way of using these type of technologies, metaverse, Web 3.0, Web 2.0. We had now we have 3.0. So yes, we have old law, you can say 2000. It was amended in 2008. IT was enacted in 2000, where there was no Google, no Facebook. Now we have intermediaries, but still, yes, government has done a very good job, you can say, by way of coming up with two rules, you can say intermediate rules 2021 and recently certain rules. So yes, we are waiting for amendment of IT Act, you can say, and are some strong rules. We are waiting for data protection law. We are waiting for cryptocurrency law also. So to cover up these things, we are waiting also for IoT devices also. What about the vulnerability? What about the check and means check and balance of regarding these type of devices? Whether so, Make in India concept is very strong, because now we have control measures in India also. We are making manufacturing devices, so we can control these type of devices. There is no backdoor channel, so anybody can intrude in my system or other system. So yes, but there are so many vulnerabilities in cyberspace and devices as concerned. So as a netizen, we have to be careful. Cyber hygiene is very important. Cyber discipline is very important, and cyber literacy is very important. So what type of website you are using, what type of new technology you are using. We don't know what type of technology we are using, but we have to be very careful by adopting new technology. Yes, we cannot means run away from the technology. We have to be in technology and atmosphere or ecosystem. But yes, we have some issues regarding investigation part also, because mostly they are having servers abroad. We don't have any mutual legal assistance treaty or extradition treaty with these countries. So criminals are using for like a safe harbor. You can say they are hiding their activities. They are anonymous because of these type of things.
Yes, sir. So there's another question that we got, that if somebody uploads your picture on Facebook without your permission and he or she is not ready to remove it, how can we remove?
Yes, now after 2021, you have rules. Yes, you can notify that intermediary that this information has been abused and I have not granted the permission. And within 24 hours, your information must be acknowledged by the intermediary, and they have to redress within 15 days. If they fail to do so, so you can lodge an FIR against that intermediary also, that I have already intimated they have failed to comply with these guidelines. And after issuing notice by way of that law enforcement agency, within 24 hours, they have to remove that content if there is any obscene or any type of privacy breach content. And you can also approach before the court. Yes, honorable court can also issue directions under like 499 and 500 part. It's a non-cognizable offense. So honorable court can also direct that remove this content. Yeah.
So we spoke about section 79A with regard to the notified examiners, electronic evidence examiners, and there are 10, as you have told us. So, sir, if the forensic expert report has come from a lab which is not electronically, which is not notified, then what would be the relevancy of that report?
If there is any objection, suppose what happens, no, there is no issue regarding relevancy. But if there is any challenge before the court during trial and defense has objected, suppose in 207 application I have filed, and you have report on, you have filed a report, the IO has filed a report of FSL. I got the image copy of that hard disk, and I got got FSL report from third party, like you can say private organizations. And if there is any objection raised, they found there is a foul play. or there is some issue. So I can raise before the court. It is not acceptable, but I can raise before the court. Honorable court can, in that part, can seek an expert opinion under section 79A labs. Or if there is any issue regarding court, like proactive approach also you can say. So because the 45A says when in a proceeding, court seeks to get the like expert opinion. So court can seek an expert opinion under section 79A.
So we are talking about the cybercrime awareness. You have also guided us as to we should remain cyber hygienic. So this is a question not only as a judicial officer but also as a netizen, that how can we get the redressal when there's a cybercrime committed against us?
Yeah, it's a very good question. Like it says golden time, like heart and brain. If there is any cardiac arrest, so we have to be careful within 4 or 5 minutes. Yeah. So like sorbitate and disprin, you can say. So same in here. Yeah, because 1930 is a very important part. 1930 is a number. If you are in a remote area part, you cannot go before like law enforcement agency. You cannot contact. So, but I advise you all that immediately approach cyber cell. Immediately rush to cyber cell. They can stop transactions because they are empowered. Now they have the complete nodal agency list. They can mail, they can block that money from one part to another part, like Paytm to Mobivic to Google Pay or Phone Pay, you can say. So within time limit, and the most important part is the 6th July 2017. If there is a monetary crime. So 6th July 2017 is the RBI notification where there is any cyber crime like monetary crime happened. So the complainant has to, the customer has to inform the bank immediately within 72 hours. And he has to fill up the DCF form, that is known as dispute claim form. That he has not compromised his information, he has not disseminated his OTP. So otherwise the company's bank is liable, bank has to pay the money back. But if there is any negligence part of the customer, the bank will not refund the amount. So yes, but as far as cyber crime is concerned, immediate response is required. Immediate contact the cyber police station so that we can track these criminals, because they are anonymous. They know the technology, how to hide. They can clear the tracks also. So now they are using anti-forensic tools also. They are using anonymity. They are hiding tools. They are using another person's identity also. Like we have email disposal emails also. So for 15 minutes, I can use email. So afterwards, there will be no email details, right? From where you can get which email ID I used for Facebook, right? I use that emaildisposal.com for temporary emails. We have so many websites, so I can use that email to log in for to create a Facebook account. So what Facebook will disclose this email. This email nobody can track this email because I've used the fake like temporary email.com. I got for 15 minutes that email ID. So that is the most important part. So immediate response is important. So alert. So first part is the awareness, then alertness, then reporting.
Yes. Yes.
So immediately reporting is very important.
Yes. So what if someone tries to impersonate us on the internet on a messaging app pretending to be someone else? What offenses are attracted in this scenario?
Yeah, if he wants to cheat, if he has cheated, that is 66D 468, you can say, creating a forged electronic record. So if I'm means impersonating like another person's identity, that is creating a forged electronic record, that is non-available 468 and 66D also, and I'm using another person identity, that is 66C. So 66C, 66D and 468 of IPC.
Yes, sir. Thank you very much for such an enlightening session, and I hope that with this session, our audience has now some clarity on the IT Act and as well as the application of the IPC. And of course, as you have guided us with regard to the judgment of State of Karnataka versus Virender Khanna, this is a very important judgment. So far, the judicial officers are concerned when the investigation process is going on and the accused is arrested, and some material is to be taken out from him from his electronic equipment. So that's a very important judgment. You have also covered Justice Puttaswamy judgment on the right to privacy and also the jurisdictional issues, and of course all other relevant sections. So I thank you very much, sir. Thank you for giving your valuable time to us.